The United States Supreme Court declined to review a major election case involving who has the legal authority to enforce certain provisions of the Voting Rights Act. By denying review to the case, the Supreme Court left in place a highly contested ruling that came out of the Eighth Circuit Court of Appeals. This denial leaves a distinct split in place between how federal voting laws are enforced in the Eighth Circuit compared to the rest of the country. Today, we're going to look at what happened in this case, the legal arguments from both sides, and why this procedural question has divided the federal courts, but also the Supreme Court as well, and how this may impact the upcoming election going forward. Now, before we jump into what the Supreme Court did in this ruling, if you like this type of content and you want to ensure that you get it going forward, make sure to subscribe to the channel and turn on all notifications. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. They just added in a whole new training division, so if you're a member, you get free access to high-level online training from companies like Achilles Heel Tactical, and you also get significant discounts to go train with them in person. So if you're interested, check them out using the links down below, and if you use my code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family fee. Now, to understand how this case reached the Supreme Court, we have to look at the underlying conflict between Arkansas state law and federal laws as well. So Arkansas passed a statute establishing that an individual cannot assist more than 6 voters in marking or casting a ballot during a current election. Assisting a 7th person triggers a Class A misdemeanor under that state law. The state's rationale for those types of caps that they put in place is typically rooted in election administration, preventing improper influence, and maintaining order at the polling places. However, Section 208 of the Federal Voting Rights Act states that any voter who requires assistance due to blindness, disability, or the inability to read or write may be assisted by a person of the voter's choice, with narrow exceptions like the employer or the union officer. An organization called Arkansas United, which provides bilingual volunteers to help non-English proficient voters or speakers to vote, they filed a lawsuit against this specific Arkansas law. They argue that the state's 6-voter cap directly conflicted with the broad assistance guarantees of federal law, stating that it had turned away voters during the 2020 election to avoid criminal liability, so they said that they were not able to operate the way that they wanted and give the assistance that they wanted through their organization because of this voter cap. Now, on review, the federal district court who reviewed this issue initially agreed with that organization, the plaintiffs, ruling that the federal law preempted the state cap that was put in place, and they said that it violated the supremacy clause. Now, in response, the state of Arkansas appealed up to the 8th Circuit, and on review, the 8th Circuit Court of Appeals did not rule on whether the 6-voter cap itself was valid. Instead, they focused entirely on a threshold procedural question, which is, do private groups have the legal standing to bring a lawsuit under Section 208? The 8th Circuit panel ruled that they do not, so they ruled against the organization. The court's argument relied heavily on strict textualist and structural interpretation of certain federal statutes. They pointed out that the Voting Rights Act itself explicitly has textual language that grants the U.S. Attorney General, and it gives them the power to bring these types of enforcement lawsuits, but it does not have the same language allowing private citizens to do the same thing. So under standard statutory construction, if Congress explicitly names one party to enforce a law, courts generally assume that Congress intended to exclude others. So since they left out a private action or allowing these types of guarantees for organizations, the court here found that the text simply does not support them bringing this type of lawsuit. Therefore, the 8th Circuit concluded that enforcing Section 208 is strictly the responsibility of the executive branch, not private litigants like the group here, Arkansas United. Now, on the other side of the debate, the plaintiffs had several dissenting judges argue that this interpretation upends decades of legal precedent. Their argument is that for over half a century, the vast majority of Voting Rights Act enforcements have actually been carried out by private individuals and civil rights groups who courts universally have recognized the right to bring these lawsuits. They contended that Congress passed the Voting Rights Act with the implied understanding that private citizens would act on their own to ensure that the law was actually enforced, especially with the limited resources of the DOJ and no guarantee that they will always bring these lawsuits. This disagreement has created a very sharp circuit split as well. The 5th and 6th circuits, along with numerous other district courts across the nation, have previously allowed private plaintiffs to bring Section 208 claims. So within the 8th Circuit itself, you also had the Chief Judge Colton, who dissented from this opinion, arguing that the panel's decision deviated from historical practices and also the broader consensus of the federal courts. That ruling by the 8th Circuit then led the group here to file for Supreme Court review. They argue that the Supreme Court must grant review to this case because the 8th Circuit's ruling created a direct and stark conflict with settled precedent from other federal courts, such as the 5th Circuit and 6th Circuit, which have for a long time allowed these types of private enforcement actions under Section 208. So they contended that leaving the circuit split unresolved would result in a fractured system where federal voting protections are administered essentially different based on where the lawsuit is brought. Furthermore, the group argued that the panel's strict textualist approach departed from decades of established practices, and that stripping private litigants of standing would severely undermine the enforcement of this specific law. They argued that without assistance from these types of groups like Arkansas United, individuals or these vulnerable voters who can't read or write or have disabilities, they would not be able to vote the way that they would with the help of these organizations. However, in response to all of this, we got the decision from the Supreme Court and they denied review to the case. By denying cert, the Supreme Court has chosen not to resolve this split for the time being. So the practical result is that in states like Arkansas, Missouri, Iowa, or Nebraska, any challenges to voter assistance laws under Section 208 must be initiated by the federal government. So in other parts of the country, private lawsuits may still remain a valid avenue, but based on the 8th Circuit's ruling, it's no longer a valid avenue in that circuit. Also, this means for now, the Arkansas law that they put in place will likely be enforceable for the upcoming election cycle. So let me know what your thoughts are down below about this 8th Circuit ruling. Let me know what you think about this Arkansas law and the procedural finding that was used to dismiss this case. Leave your thoughts down below in the comment section about what you think that Arkansas did, and do you agree with the Supreme Court denying review to this case and leaving in place what the 8th Circuit ruled on? Also, if you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.